Evening, everybody. Let me call the meeting to order. So this meeting is being recorded, everyone. Help me out, Flo, with who's in the meeting, because I can't see everybody on my screen.
Oh, okay, everybody's here today.
Okay. So we won't be seeing an alternate this evening. Any changes or additions to the agenda, Paula?
No, there isn't.
Okay. The minutes of the July 26th meeting, July 26, 2021 meeting. Any correction or changes?
I have a
So I'll
correction.
make a motion. Pardon me?
Vera has a correction.
Okay. Did I hear that somebody had a correction?
Yeah, I had a correction, Vera.
Okay. Go ahead, please.
Okay, one of the questions I had asked if the wedding venue was going to be catered or cooking on site. Was the cooking on site that was omitted? I'd like to put that back in.
Okay, so so you would like the minutes to reflect that your question reflected a question about also whether or not there would be cooking on site. And that was
Right.
not in the minutes. Okay.
I.e. a professional kitchen.
Well, what exactly did you say at the last meeting? If you could reflect that, because I'd like the minutes to just reflect what was exactly said at the meeting, not something different. Could you just give Flo that verbiage that you used? I don't recollect it.
I was asking if there would be any food preparation and cooking on site.
Okay. Flo, can you make that modification?
I will.
Okay, any other
Thank you.
corrections? Okay, so I'll make a motion that we accept the minutes as modified and are corrected. That would be Larry seconded that. Any discussion? All those in favor? Aye.
Aye.
Unanimous? Any nays or abstentions? Okay, so the minutes are approved as correct. Next up, under audience of citizens, Mr. Tabor had discussed getting a perspective from us about solar regulations. Would anyone else like to bring anything up, or Mr. Tabor, would you like to speak, or?
You had asked me to put him on the agenda. He's on the agenda under 7.1 new business.
Oh, that's correct. Okay, so we'll pass on that topic for the moment. Next up is anything else from the public? Next up is, we'll go to item 6, unfinished business. We have the Hop River LLC 4-lot subdivision. The application on Hop River Road, property address 127 Route 6, assessors map 8, lot 16A. So our discussion was deferred to this next meeting, and the biggest, if any issue, if it may be the only issue, was wanting to know that there was an agreement about the easement language. And could you update us, or Mr. Walter, could you speak to that? Either Paula or
I'll
Mark
start.
Walter?
I'll start.
Excuse me, Paula, before you start, is this part of the public hearing?
No, the public hearing was closed a few weeks ago.
The agenda says continue public hearing.
No, it says unfinished business, 6.1 Hop River
Yeah,
LLC.
but just below that, it says continue public hearing.
Yes, that's for the application of Valley Street Investments.
Okay.
Yeah, that's a
Okay.
different
I'm sorry.
topic,
I'm
Bob.
sorry. Yeah, you got it.
Yeah, item 6.1 is just we closed the public hearing, so we're in a mode where we're simply going to be not getting so much new public information, but information to make sure that we can make a clean decision and action on this application.
Sorry, I was getting ahead of myself. I apologize.
That's fine. So that said, Paula, were you going to weigh in about the easement language?
Yes, I had worked with Attorney Rich Roberts of Halloran and Sage. I asked him to prepare a draft easement. I modified it a little bit and went back and forth with Rich Roberts. It was then reviewed by the town administrator, and I then passed it on to Mr. Giuliano. And I think we're getting really, really close. Mr. Giuliano has passed it on. I shouldn't say really close. We're in agreement on everything that needs to be in the easement. Mr. Giuliano has passed it on to his attorney, who will, as soon as we hear from him, everything will be set. At this point, it's a dialogue, in my opinion, it's a dialogue between the property owner, Mr. Giuliano, the town administrator, and the two attorneys. Did everybody receive a copy of the draft? It was sent out later to, maybe 11 o'clock this morning.
I haven't been anywhere to review anything today. I've been on the road almost all day. I saw an easement, I see an easement draft. Yeah, sent out at 11:26. So I just got in off the road. So has anyone else reviewed this on the commission? I'm looking at it right now.
Yes,
This is what it's a 5-page document. Mostly the 5th page is a signing block. Talks about notices, indemnification. Paula, could you summarize the essence of what's in here verbally for us? We'd like to know that the concern that I had at the last meeting was, what is the scope of the temporary easement until the permanent easement is built out by the town, permanent easement area is built out by the town? And then what is the agreement for the language? We can read it verbatim, or if we could get a summary of it, it would be helpful. Whether Paula, you or Mark Walter speak to that from the town's perspective, that would be helpful.
I can read it. I have it in front of me. Talks about the temporary easement, that the grantor, which is Mr. Giuliano, and we're the grantee, which every time I read one of these, I have to like, who's who? So the grantor does for itself, its successors, and assigns. So in perpetuity, hereby declares and reserve for the benefit of their successors and assigns a temporary easement over the existing gravel path on the open space parcel as an exclusive easement. And then, so there's a temporary access easement for the purpose of pedestrian and vehicular ingress and egress over the existing gravel path to the benefited parcel, which is lot 3, for land management and passive recreational purposes. Grantee, that's the town, will have the right to use the access to allow access by equipment or vehicles needed to mow or clear brush or otherwise maintain or enhance the open space parcel. The temporary easement is across the gravel path that starts within where you all walked through, and then ends up, it continues on the north side of the Sleuthway, and then across the like a gravel area. And we're both guaranteeing that both sides are guaranteeing that we're not going to block the temporary easement by parking trucks or cars in the middle of it. And the temporary easement shall be extinguished when either the grantor or the grantee has constructed a driveway from Hop River Road terminating on the north side of the Sluiceway, as shown on sheet 2 of the subdivision as the future access driveway. The town plans to put in a driveway that starts at Hop River Road, goes to the south of the stone arch that's there, and going across, going over the Sluiceway, and then not continuing the driveway further on in terms of doing work from that point on. And the lot 3 owner would need to continue that. So once so the temporary easement is temporary until the driveway is put through. And then once the driveway is put through by the town or the lot 3 to reach to the other side of the sluiceway, then it becomes a permanent easement. And it's non-exclusive. Town folks will be able to walk on the easement area. It isn't exclusive for the lot 3 owner to have that. And lot 3 shall have the right to use that permanent access easement for the purpose of pedestrian and vehicular ingress and egress to and from the benefited parcel for land management and passive recreation. The town will have the right to use that area. And again, we're both promising to not, park stuff in the way that nobody can, that the other side can't drive through if they need to. We'll have a gate. The town will put up a gate, and we will provide access to the grantor with a key or an access code or whatever system that we have. The typical obligation to maintain and repair the permanent easement, the portion of the driveway that the town has built, the town will maintain and repair that. The area of the driveway that the lot 3 person has put in, if they so choose, would maintain that. And then there's insurance back and forth in terms of who's making sure that the parties are insured in case there's an accident or an issue. Mr. Giuliano has forwarded this to his attorney, and we've not heard back from his attorney. I don't think there'll be too many concerns with it, but.
Okay,
So this means that the town will be responsible for any wetlands permits as far as running the access
Yes.
across the sluiceway.
Yes,
Okay.
if the town, if lot 3 gets tired of waiting for the town to do it, I don't think that's going to be the case, because I believe the town will take care of this over the next winter or two. But if lot 3 wants the driveway to happen sooner, then lot 3 has the right to do that if they want to put in a driveway.
Is there any time limit imposed on the town for when we are supposed to have this done?
No.
Larry, if you have questions about that, maybe Mark Walter could answer them about the intended time frame for the town to get this done.
Sure, Rick. The time frame is dependent upon a mild winter. This type of work is done in the winter when we're not buried in road and drainage work, which normally eats up our public works crew's ability. And the last 2 winters have been very mild, and as a result, we've been able to achieve a lot of modifications to our rec park. And this road or driveway to be put to the lower side of the sluiceway is not a big challenge. We just need a mild winter to do it. So either this winter or next winter, I'm sure it'll be done.
Okay. Larry, does that address what I think was in your mind about that caused the question to be asked?
Yes.
Okay. I'm comfortable with it being left in the town's hands or Mr. Mark Walter's hands. Okay. Any other questions? Any comments, concerns from the commission? Tom? Tom, you're muted right now.
Okay, here I am. I don't know what happened. I guess I'm not totally comfortable with being open-ended. I don't know if you want to put 2 years or 3 years, but I would like to see a date. I'm not saying, well, Mark, you wouldn't do it. Obviously, I'm just saying, what happens if it just gets, for whatever reason, just gets getting put off?
Well, the reason the town wants the flexibility is that the existing easement, the temporary easement, is a perfectly usable easement to get to the next, to lot 3. So if it takes a little more, it is zero inconvenience to anybody except for archaeologists that want to dig up the entire old mill.
Okay,
Which I can't imagine.
all right.
It
That's my thought.
is a huge concern.
I wanted to see the verbiage on what would transition from the temporary to the permanent, and I'm comfortable with that. I don't have any real questions here, other than maybe of Mr. Giuliano. How close are you to signing off on this?
Good evening, Mr. Chair and everyone else. How are you? We're very close. I think the town planner described it perfectly, where essentially we have an agreement in principle, let's say. I think the attorneys really just need to dot some i's and cross some t's in their lingo. But in terms of the mechanics of what we're doing, we're perfectly comfortable from our side. I think I can, on the timing issue, it's certainly our intent to move forward with the conveyance much sooner rather than later. So as soon as there's a vote and the appeal period expires, we're working towards an early conveyance. So if this winter is possible, we're certainly going to move things along in that nature.
Thank you.
Okay.
So to the commission, I would say, I wanted to see something at this level of refinement before we took action on the subdivision approval. I'm comfortable letting any further modifications of this agreement be worked out by our town administrator and our town attorney, with input from our town planner. Ultimately, it's, and the town will have to take it, but I'm comfortable with the level of finish. I'd like to hear from the other commission members if you're comfortable with potentially moving forward on a vote on this subdivision based on what we've been presented to this point.
Okay.
Tom, you're good with moving forward?
Yeah, I'm good with it.
Anyone not comfortable moving forward with the
Well,
amount of information we have?
Rick, we still don't have sign off from the applicant's attorney. They
We
have
don't
not.
have final sign off.
Right. Right.
Yeah, you're right. Yeah, that could be a concern.
Yep. So I'm a little hesitant to sort of approve it with a blanket approval. I mean, you don't know what that attorney is going to come back with.
How long has it been with the applicant's attorney for
Just a few
review?
days. It's just been a few days.
So it took
Last
us
Thursday or
a
something.
good 10 days to generate this and get it out for review.
Mr. Giuliano and I worked back and forth for a few days as well before he
Mr.
sent it to his
Giuliano?
attorney.
Yes,
Yes, I can share that. So Jack Barnarcha is our attorney, and Jack certainly knows about it. He was just unable to get to it. They're swamped with closings, and he, certainly he expressed to me. He said if the P&Z so desires, they can approve it conditionally, subject to the satisfaction of the town administrator, town planner, being satisfied with the document. So I think, that threshold can certainly be established, and probably would be established in any ordinary course of contingent approval.
so yeah, that would be my question to the commission. Are you comfortable giving approval conditioned on the successful agreement being reached and put in place by the town administrator with the sign off from Paula? I don't mind delegating that. I'm comfortable with them representing the town's interests. So that's really my question to the commission. Are you okay with approving it? And then if they take them 1 or 2 more days, that's our approval is effective as of that date. I'm not seeing smiles all around. I really want to hear what
I-
people have.
I'm okay with that.
Yeah, I'm okay with that too. I'm not seated, but my opinion is yes, move it forward, please.
Okay,
The easement is actually between the property owner and the town because it's on the open space land. So they're the two sides that need to come to terms with it. And I think they're 99% there.
I also think that if the landowner is satisfied with it as written, technically he doesn't need his lawyer's approval. He can approve it. He's just looking to his lawyer for advice. So if he's happy with it, I'm happy with it.
Except that whenever you get lawyers involved, they're going to justify their existence by having something changed.
That's correct. That's correct. But he can tell them this is the way I want it. And that's the way it should be.
It may be certain language that's changed, but not the intent, and the outcome would not change.
It would be a lot cleaner if the approval was done without any conditions.
It can never happen with a subdivision, Bob.
I think Bob's comment was in the context of the right to access over the land. I don't think he's talking about all of the other conditions. I think we all understand that. Am I correct, Bob?
Sorry for the misunderstanding. I've been here for 8 years now, which I just noticed today, which was sort of a surprise. I don't, it creeps up on you. All the easements that have happened in subdivisions since I've been here, it's always been subject to, that an easement being placed for the benefit of whatever as part of the approval of the subdivision.
I'm not sure how that applies here.
Same, it's an easement. It's an easement just like any other easement.
Well, it's an unresolved easement as of this moment, and I understand Bob's concern. I'm very comfortable delegating it to our staff to get the final verbiage as long as we knew the general structure of it. But the point is, I really wish we had the finalized language for the easement in front of us so that it would be a clean approval, not contingent on some external event. That's what I was trying to avoid by going this extra 2 weeks.
I think
So-
if you can, Rick, the town attorney is not going to allow the easement to harm the town in any way. And the main verbiage we just need to finalize is insurance indemnification. And once that's locked in, which is really the town and my responsibility, everything will be fine. But the language that we are in agreement to is access to the property through both the temporary and then finally the permanent easement is fine. It's just the dotting the i's, and I think we're real close to that. And that'll be my responsibility and the town attorney.
I think if the town is confident in resolving any outstanding issues, then I would be inclined to agree, and we could approve it with that condition.
I feel the same way. I think it's well put, Bob. Everyone else any concerns to address, or can we move to a vote on this? And I assume, Paula, your draft motion takes into account the status of the current state of the access easement.
The in terms of the list of things that need to happen prior to the endorsement by the commission, so you still have final control of the final subdivision plans for filing in the office of the town clerk. The last item on those bullets is the access easement. Deeds for all the land to be deeded to the town, Gamache and Grenacy, have been executed and ready to be recorded on the Columbia Land Records once the final subdivision plans have been filed.
So the memorandum that you generated that is partially on page 4 of our packet, and also I believe page 5, all of page 5.
It's the
that
heading
is-
date on that sheet is August 9th for the August 9th meeting.
Right here, yeah, I got it.
Okay,
Correct. Yes. I have it. Okay. That said, is everybody comfortable moving forward with this motion? Would you like me to read through it, or would anyone else like to volunteer to do that? Mr. Giuliano?
I have one question, and that is on the, we've agreed to convey to Gamache, et cetera. What if they refuse to accept?
I don't see that as sinking our approval. How do the other commission members feel?
That's
That was
the-
rectifying a property boundary. What if they come back and they want 20 feet around the barn instead of 5 feet?
Or just they refuse to accept? I mean, they, you know, I'm just trying to
No,
ensure
I
that I
appreciate you
don't
bringing
create
it
a,
up.
yeah, I don't want to create a potential stumbling block if they just simply say, hey, we don't want to do this.
Okay,
Have you
you
talked to them? Has anyone talked to them about this?
Nope, I haven't talked to them. I don't have approval to do this yet, so I'm not talking to them about it until I have approval.
I believe Mr. Wentworth did contact them. I could be wrong, but I believe he did.
That's another issue. If it isn't granted, that doesn't really affect my perspective on this. If we vote to approve, it doesn't affect my perspective on this. That was to benefit that neighbor. That was the only reason I had it, just so that a future owner of this property couldn't come in with a bulldozer and tear down part of their barn.
I raise it not because I expect them to. I don't want to create kind of a unforeseen sort of, you know, hitch in this.
Well, if we vote to, Paula, maybe you could give me a perspective. If we vote to approve it with that modification and they refuse to accept the land, what does that do to our approval if the approval isn't put into effect in the way that we've approved it?
In that case, I think that would be fine. I would be surprised, especially the Gamaches wouldn't accept it. And the other transfer, in addition to the open space, is the Grenacies, which have they did a free split 3 years ago, perhaps. It's the home that's on Hop River that was the Giuliano home. In order to be able to do a free split, the property couldn't touch the back property, the new property for the house couldn't touch the back property line. It had to be set back from that, so that, because otherwise it would have created a new lot on either side of it. And my agreement with Rob Hellstrom when they did the free split was that when the subdivision, because we'd already known that at some point a subdivision was happening, that land that was behind their Grenacies would, and it's 10 feet by 200 feet or something, would be deeded to them. Otherwise, one of the properties owns in behind this one is just too. One of my goals is to not someday, 100 years from now, somebody's not looking at a lot line and saying, what? Why is it like this? This makes no sense.
Everything you explained, Paula, in all sincerity, I have no idea what you're talking about.
Okay.
Because I
All
don't
right.
have a map in front of me.
Okay.
I haven't been
All
going
right.
over the maps recently.
You can see it on the subdivision map. It's the homestead property does not touch the rear property line.
And so why are we bringing this up tonight? I'm not sure I
Because
understand.
that's one of the deeds that needs to be given to someone. A little strip of land needs to be given to somebody.
So it sounds like it's currently drafted as a condition of the subdivision approval. So the only reason I raised
understand
it.
that.
Okay.
No, I understand that.
No, I don't, it's, I think not having the deed for the town open space not being recorded, that would be an issue. The other two, I don't see where that would be an issue in terms of the subdivision.
Okay. What's the commission's pleasure here? We move forward with this?
Yes.
Forward,
Vote.
yes.
Okay,
Take a vote.
then let me read the motion out loud. And is the motion as it's in this page 4 and 5 version acceptable to cover everything that we came up with tonight? under the conditions, Paula? I haven't had a chance to
Yes.
review this. Okay.
Yes, I thought you were asking the commission members. Yes,
Yeah.
it does.
Okay, so I'm going to make a motion to approve the Hop River LLC subdivision application based on the submitted application and revised site plans dated July 9, 2021, and statements made by the applicant and applicant's agent at the hearing with the following changes. No changes,
No
correct?
changes, correct.
No, so I'll omit with the following changes. So the conditions are: prior to the endorsement by the commission of the final subdivision plans for filing in the office of the town clerk, the following is required. The approval letters shall be added to the final subdivision plans from Inland Wetlands and Watercourses Commission and/or its agent, Town Sanitarian, and Planning and Zoning Commission. The approval notes from the PZC shall be added to the final subdivision plans. All boundary pins and monuments shall be set at angle points and at 500-foot intervals for all straight segments and field verified by the surveyor and noted on the final plans. A performance bond for the installation of the dry hydrant in the amount of $6,000 has been provided to the town. The access easement deeds to the land to be deeded to the town, Gamache and Granisi, is that the way to pronounce it?
I believe so.
Have been executed and are ready to be recorded on the town land records once the final subdivision plans have been filed. Approval notes, Lot 4 subdivision by Hop River LLC. Prior to the sale of lots, subdivision applicant shall provide an estimate of the erosion and sedimentation controls required on each lot, including any controls that will be necessary within the town right-of-way in order to accommodate individual lot development. Prior to the issuance of a building permit, the proposed site development plan shall be reviewed by the town planner to determine if the approved drainage plan was modified or if there's a change in structure location that requires revised drainage requires a revised drainage plan by a professional engineer, fee to be paid by the permit applicant, excuse me. Number 2, erosion and sedimentation control bonds for individual lots shall be submitted to the town of Columbia in the amount identified in the approved estimate and approved by the town planner. Number 3, the developer shall notify the Columbia ZEO at least 7 days in advance of any site work to schedule a pre-construction meeting. Number 4, driveway permits must be obtained from the Columbia Building Department in accordance with the adopted policy concerning driveway access. And number 5, should any rock blasting be required, the developer is encouraged to notify property owners within 500 feet of the lot on which the blasting will occur at least 1 week in advance and offer a pre-blast survey by a qualified structural engineer. That's it. Any, do I have a second?
I'll second that.
Any discussion? All those no discussion, all those in favor? Aye.
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 Opposed?
Aye.
Abstentions? Okay, that's unanimous. The motion is approved. Thank you, Mr. Giuliano. This is well presented.
Thank you very much, everyone.
Paula, thank you for your work. And Mark, thank you for your work. I appreciate it. Okay. You know how this goes. Next up. We opened a public hearing on the application of Valley Street Investments LLC for zoning regulation amendment to section 9 definitions, section 21.2.3.16 and section 52.7.5 to allow event/wedding venue in a residential agricultural district. So where are we on this, Paula?
You had asked for some revisions to the, after a discussion 2 weeks ago, asked for them to consider revising some of the regulations and their proposed regulations. And they submitted a revision which went out. It came in 10 minutes after the packet went out. So it went out as a separate document on Thursday.
Okay, we
Mr.
have those.
Glad
as
is
a
here.
Has everyone had a chance to review this? I'll be, in all sincerity, I have not up until this evening. So that being said, should we go through those proposed revisions and ask any questions? Or Mr. Glad, would you like to go through those for your client?
Yeah.
That might be a more efficient way to approach this.
Yep.
Thank you.
Okay, for the record, Greg Glad at Killingly Engineering Associates. So we did make some revisions. I took some notes from our meeting two weeks ago. And I'll just detail the sections that we changed or added. The second part of our regulations there, section 21.2.3, which was the event wedding venue facility. I corrected that section where it referenced section 52.7.5. So I've made that correction. I think last time we had the wrong numbers there. If we go down to section 52.7, the special standards applicable to specific uses, we had 10 items before. We still have 10 items. I added one item and then I bumped one item out, which was the sign portion. So the item that I added was section A. I added a statement of use. A statement of use shall be submitted describing in detail the nature and scope of the event/wedding facility and the maximum numbers of attendees proposed for the site. I wanted to add that basically that would address a lot of the questions that might come up so that when we get into a more site-specific application or the special permit application, we would be able to detail things such as whether the food prepping would be on-site or off-site. Our applicant proposes for his food prep to be catered, but I didn't know how detailed we wanted to get with that sort of thing. So I wanted to put that in there that someone coming forward with an application would have to specify all of these uses. The next section that changes is section G, and that's the noise section. And I think that's the section we had the most discussion on last week or 2 weeks ago. So I revised that to say noise, that music from any event or reception shall take place indoors. If a temporary tent is used for the indoor space, it shall be classified as a soundproof tent. Only low-level background music may be allowed outdoors during the ceremony. And I'll give a little bit of detailed explanation of that. So we did some research in regarding as to what's out there for a temporary structure or tent structure. There are several companies that create these padded or thick padded tent walls and roofs that are classified as soundproof. There are also acoustical engineering companies that make panels that attach to tents. So depending on when they come forward, the state of their specific site, they would specify what they're using, whether it's indoors or with a tent. I did add for that we would allow asking for low-level background music during the ceremony. I think last month someone brought up the St. Clement's in Middletown facility. There they have outdoor facility weddings. They take place outdoors, as will our venue, but the weddings take place outdoors. In their case, they overlook the Connecticut River. There they have low-level music playing, and it's really only during the waiting portion before the ceremony. It's not allowed music. It is very low level. We do the same thing in Hampton. We had that added to the regulations. There have been no complaints. Again, it's almost like conversation sound. If you've ever been to an outdoor wedding, you always know that during the waiting period before the wedding, there's a low-level music playing. So we're asking that that be allowed. Again, low-level background music only at the outdoors during the ceremony. And I would suspect that we may have some conversations tonight about that. So that was the next change. And then section I, during the traffic safety, we left in all driveway entrances to the site shall be designed to ensure safety and ease of access to the public street or highway, taking into account grades and line of sight for vehicles entering and or exiting the site. If not located on a state road, a traffic study shall, and I think we're missing the word shall, A traffic study shall be conducted to ensure safe travels between the state road and the facility. So instead of saying we recommended or we would, if it was asked for, we're saying that we would provide one if we're on a town road. And again, that there is a word missing there that should have said shall be conducted. Item J stays the same, the on-site parking. And then the new section that we added is section 62.5. And that's permitted signs in a residential or mixed-use district. So I think last time that was one comment was that we moved that sign regulation and put it where it belongs in the sign portion of the regulations. And you'll see we kind of just matched the and added the following would be added to the table that you have. And then under an approved event/wedding facility, the maximum number of signs would be one sign each at each street entrance. I put maximum of 2. That's open for discussion. Maximum area and height would be 10 square feet in area, 8 foot in height. And then I kept some of the same additional requirements, some of the same language we had last time. Lighting shall be shielded by light source for up to 2 hours before an event until 11 p.m. No flashing lights permitted and a separate sign permit is required. I think that would take care of that. I didn't add anything else, but one of the comments I think was last month too was that we had some times that didn't line up, and that was basically the event hours being from 11 a.m. to 11 p.m. And then we had how we would do the noise. But since we removed that and changed our noise section, there's no longer a conflict there. That's really what we've added and changed. So I'll turn it back to you, Mr. Chairman, for any questions.
Thank you. Do we have any questions from the commission members or comments? I just one quick thought, if no one else has one. If we were inclined to go with this, I'm not completely comfortable with describing noise as low level. Something to the effect of not audible in any way outside the property boundaries for the outside sound might be something that's less subjective. And if you can hear it at the property boundaries, then that outside noise would not be acceptable. And if it's low enough level on a large property, I don't think that's going to be an issue at all. But some caveat like that, I think, would address my concern about noise in a residential neighborhood. And going to where a soundproof tent, basically no music should be heard off of the site. If you're sitting in your living room next door to an event facility, I don't think you should have to listen to the music going on at the event facility. Otherwise, it's interrupting the character of a residential neighborhood. And I think what's here goes a long way toward that. It would be a minor modification.
Yeah, and we're not opposed to that language that you just suggested about not audible on that background music outside the property lines. We're not objected to that. We know it's going to take place well inside of our property lines, so it should not be an issue.
Yeah, I didn't think it would be, but that would be a way that would address pretty much all of my concerns about sound. Then it becomes a non-issue. They're sending the sound indoors. We're to be contained indoors. But my thought would be that would apply to all musical. I don't want to call music noise, but for lack of a better word in my mind. But so that as long as music generated on site is not audible off site, if that's going to be a workable thing for the applicant, that would go a long way. That was probably my largest consideration. The other one obviously is addressing traffic. If a traffic study is going to sufficiently give us information to make a decision on an application, then I feel comfortable with that. So that said, I want to just open this up to anyone else on the commission. Paula, any comments, thoughts, and then we'll open it up to the public.
I appreciate the revised language. I'm trying to figure out exactly how you would want to amend the noise. section, but we don't need to come up with that at this point. But I like the idea of it not being audible beyond the property boundary or.
That's a pretty objective standard that I think is easy for people to understand and easy, it's a bit of a challenge to adhere to maybe, but it's an easy standard that could be out there to protect the public. That was one of my biggest concerns here, is changing the character of adjoining residential properties because of noise. And the other one, like I said, is traffic, but as Mr. Glaude pointed out, given the size of the events and the fact that people rarely leave all at once, to have a long stream late at night coming out into the property, off of the property into a public street, and the need for a traffic study. I want to hear what everyone else has to say about that. I just want to put that as one thing that's in my mind that I'm hoping that we are all comfortable with, and if we're not, that we have a discussion about. Anyone else from the commission? Shall I move to the public comments?
I have a
don't know.
Question, Rick.
Justin?
Okay, real quick. On item D, the maximum of 15 events shall be allowed per calendar year. What's the process to determine that number? If from just purely a business perspective, it seems like a pretty tight restriction on the number of events you can have per year, considering
Good
the number of
question.
weeks in a year. And I mean, is that even feasible for a business to be able to sustain itself on 15 events?
I can address, my applicant, or my client. The applicant is just wishing to keep what he's looking to do a low level business here. He does not want to have more than 15 events at his particular venue. I know, Mr. Nassif, you had also talked about increasing the number. We're not opposed if you want to put a bigger number on it. We're just saying that this is the number that works for what we've got coming forward.
But I think we all want to see a business in our town succeed. That's a vital part of having a vital town, is what's here is successful, and if to the extent that we can help with that by not taking a number that may or may not work and looking at it objectively about a larger number. I sense from Justin, you feel the same way. I was open to that. I'd love to hear from the commission on that number also.
Yeah.
Well,
Rick, my concern with that is it may work for this applicant, but if there's someone who can get into the situation in the future that meets all of this criteria, 15 events may not work for their particular business situation.
That particular person would have the option of coming and modifying the regulations. I don't think, we're not in the business. We don't know what it takes to make these things work. But I think we could leave it open-ended. This 15 sounds fine. If somebody else comes in and wants to make it 25, then they can certainly apply, go through the process just like this applicant has done, and have the regulations modified.
Okay. Any other thoughts on that?
Let's face it, the applicant has much more experience as to what it takes for this to work, having other locations, than any of us on the committee. If that's what he's asking for, then he must have some experience, or he wouldn't have written it this way.
Rich, you had something. Thank you very much.
Rick, Tom, I think the 15 is way too limiting, in my opinion, especially if you have a 25 or greater acre parcel. I think I don't know how many use the number, but I think 15 is too confining for most, operations of this type. But I don't have any experience. I just think 15 is way too limiting.
Yeah, but Tom, you just said it.
Yeah, hold on
none
one
of us
second.
have any
Rich has been
experience.
Rich has been trying to weigh in. He's had his
I'm
hand up.
sorry, go ahead, Rich.
No, thank you.
All right, so basically, we're setting the groundwork for this type of business within town. I think it's wiser to extend the amount of time to make it a little bit easier on the next person versus spending more time coming to get in and getting approval. Right now, once this is approved, the next one that comes in is as long as they're within the guidelines, they shouldn't have to come to us with a lot of changes, which makes our job simpler, their job simpler, and moving forward. I mean, we did a winery and Walt's been back a bunch of times making alterations when he could have gotten them in the first round, but you know, that's live and learn. I think that we're
But there
laying the
was a- there
groundwork
was
for
a-
future business.
That was Bob. Bob, were you looking to weigh in? I forgot who.
I think what we've done so far is shown that none of us know what this business is all about. None of us can put a number on it. The applicant is the expert in this business. They want to do 15 events. They're submitting the application. We're not doing the application. They are. So if they want 15, I think we should give it to them.
I agree.
And just for a point of, Rick, for a point of clarity, so
Yeah,
so if
Larry
this
was up
to be
next.
approved.
Justin, hold
Oh,
one
I'm sorry,
second.
Larry, go ahead. I'm sorry.
Yes, I agree. The applicant is, this is what fits their business model. And if somebody else wants to come in, and they have a different model and they need more events, well, then they can come to us and explain that and we can grant it at that time. But at this point here, I agree. We're not in the business. We're just looking out to protect the town and to make it easy for business to be successful while we're protecting the town. But you know, if we're satisfied that the restrictions are okay, and if the applicant is happy with 15, I don't think we should be taking it upon ourselves to tell them something else.
Okay, Justin, you were going to
15.
say?
Yeah, just for a point of clarity. So if this was approved as written and in future, at some point, somebody wanted to do something similar to this, this wouldn't apply to them at that point. This is what we're saying. They would have to come back, and if they decided they needed more events,
If
they
they
would have
want to
get that as a
modify,
secondary approval,
if we
correct?
approve this regulation and they want to modify the regulation, they would have to come back before us and propose a regulation modification or ask us if we were open to it and we wanted to modify it in our next round of regulations. In this case, the application took the initiative to propose a regulation change to us as a commission and do a lot of underlying research and crafting a proposed regulation. Anybody can propose a regulation change. There's a fee that compensates us for the cost to advertise and things like that. So, you know, there's one of two paths if you need a regulation changed. Ask the commission if they'll do it on their dime, or you propose it formally, in which case it's on your dime.
And Mr. Chairman, if I may add, you know, one of our considerations with the site that we have is we're also trying to balance, you know, the existence in the neighborhood or with the neighbors. So keeping it a little bit lower key because we are in a residential district, we thought would go a longer way with consideration from the commission.
Okay, thank you. Does that answer your question, Justin?
Yeah, yeah. So
I still
Okay.
think it's too limiting, this time. It's just, you know, the major complaint we get from the townspeople is that, especially the business people, is that we make things too difficult and we're not business friendly. And I think this limitation of 15 fits right into that thinking.
You know, I have a similar perspective as you do, Tom, about this. What can we do to help them out from the onset? But I've been swayed by Larry and Bob's argument in that they know the business. You know, this is an outdoor event. There may not be a lot more than 15 good weekends in a theoretical year where you can operate an event that's focused in large part on a facility that really, it's not for just indoor only events. You know, their weddings are taking place outside, and so I had that feeling that you did initially, Tom, and now I'm looking at it from Larry and Bob's perspective. But yeah, we want to help.
I mean, you've got
That's the message we want to send.
You've got a minimum of 4 and maybe 5 months. And what days of the week do they? Thursday, Friday, Saturday. So you've got, let's say you've got
Sunday.
4.5 months, and you've got 3 days a week that you can do these. You know, to me,
4
that's
days.
about, you know, 30 events that they could possibly do.
So Understood.
I just really feel this, you know, I'm not swayed. I think that it should not be limited to 15, but obviously I have one vote.
Okay,
I have a comment for the letter I for the traffic study.
sure. Go, please, Vera.
I mean, it's kind of understood for us who have had reviewed those before, but there isn't any mention as to who would the traffic study be done by.
It would be the applicant, so at the applicant, so I mean, we could certainly add that to there.
By a certified traffic
I
engineer.
assumed it was
Yes.
I assumed it was a traffic engineer.
Yes, that's correct. It would be a traffic engineer.
So
Okay,
that's
but
a
the
good
but the
point.
bullet
thought you were
but the
saying the
bullet does
difference-
not say so.
Okay, that's a good point. Thank you. So we would, if we were inclined to go forward, that would be something we would want to incorporate. Everyone in agreement?
Yes.
Okay. Licensed, I think the term we would use licensed traffic engineer, Mr. Glad, is that?
Yeah, and I think that
Correct,
would fit
profession.
right in. A traffic study be conducted by a licensed traffic engineer to ensure. On
And
the third line.
usually that traffic engineer is acceptable by the town. It's presented to the town, and the town has to accept that person as the person doing the study.
Okay. So some reference, Flo, you're taking notes here. So, and Paula, so a licensed traffic engineer acceptable to, approved by the, I'd leave it with the town planner, quite frankly, by the town planner. Acceptable to the town planner. Okay. Going in the right direction. Any comments from the public on this application?
Not so much a question about the application. My question concerns that this is an
Could you just, for
open.
the record, could you just identify yourself and your address
Yes,
for the?
that's what I'm going to ask you to do. Carol Kabala, 37 Lake Road. I'm looking at your screen this evening and I have no clue as to who some of the members of your board are because they do not have their names on their pictures. I would like to know their names so that I know who had what questions this evening and I could attribute them to someone. Like, for instance, the person with the iPad, I do not know if I know this person or not. I'd like to know his name. Judy.
His name is Robert
not
Powell, and
Judy,
we,
obvious.
as a matter of convention, we don't require the commission members during a discussion where we're going back and forth to identify themselves by name each and every
Absolutely.
time. So if you do have a question, I think it's better if you ask it, we'll answer it. He's Mr. Robert Powell. He's an elected member of the commission.
But his name is not visible, so I cannot
Well,
tell.
I'm telling you what it is, and you
Okay.
know, and Judy is not Judy. His Larry Preston, who lives on Lake Woods Lane, and the 228 number is Vera Engler, who's a member of the commission. So now you know all that. Other than that, everyone has their names in the Zoom meeting. So I think that's answered, isn't it?
I think you're annoyed with me, but I think that it is.
No, I'm just
You
saying
do
that.
sound like you are.
I'm not going to go down this path with this discussion. What I was trying to say to you is, as a matter of convention, we don't identify ourselves in a meeting because of the amount of interaction. It's cumbersome for us to do it during a Zoom meeting. So I identified any of those people that there may be some question as to who they are. And if you need more information, please ask and we'll provide it for you. And I appreciate that you asked it. But don't
I agree
infer that
that
please give me a chance to finish what I'm saying. Please don't infer that I'm annoyed if I'm just trying to get the meeting to flow along procedurally at a fast pace. We just want to get our business done and done right. But I appreciate the question.
I absolutely understand that your board members would not identify themselves each and every time they spoke. But if I knew who they were right from the start, it would be helpful for me, the public, at a public meeting. And here I am. I do have my name on the screen. Obviously, I didn't put Paul's on because the two of us
This
are
is
here.
not an issue I want to take up a long dialogue during our meeting about. I've
Thank
said
you
to
very
you,
much,
no,
Rick.
just a minute. Don't cut me off. So we've identified those members, and if you ever have a question, please ask at the start of a meeting. But I'm not going to change the procedures for meetings because it's never been brought up before. This is the first time in all of the Zoom meetings that we've done. This is how we're going to do business. And if you have a question about it, I welcome that question. We'll identify them for you if you want to know, or anyone else who asks at the beginning of a meeting.
Oh,
Thank you.
thank you. And I will ask you then one more question. When you have a public meeting that is not virtual, do you have your names up on plates like the selectmen do, or the Board of Education, or at a town meeting, so that I know right from the start who's who and who's speaking?
We do.
Okay. And you don't have it here. Thank you. My point, that's my point.
That's the point. Thank you for your input. I really appreciate it. Anything else? Any other input from the public? Comments on this application? What's the commission's pleasure? Are you ready to close the public hearing? Because I think the few items that we would like to address, I think would be well within our discretion to address after we've closed the public hearing. Mr. Glad, is there anything else you'd like to add for us before we potentially close a public hearing?
So again, we're not opposed to the audible outside, the noise, that low level noise not audible outside the property line. We would be comfortable with that. And we would be comfortable with adding the language that it be a licensed traffic engineer acceptable by the town planner. And again, I know you guys are going around about the different numbers and stuff. We're not opposed to more events, just that's what we're specific. We're trying to keep it in harmony with the neighborhood. So that's one of the reasons we went with that number, and we kept it with just a few days a week as well. So we are comfortable with that number. If you guys feel that you want a few more events, we're okay with that too. So that
So let me just address some of the comments looking for a larger number. I'm not inclined to pursue that personally, but if one of the commission members wants to suggest during the public hearing, at least, that you're going to suggest when we close a public hearing, increasing that number, I'd rather get it on the record now, while the member of the public, if they were here, could comment on it. And if you're not going to propose a change like that, and you're thinking that we'll probably consider this issue with the proposed 15 events as presented by the applicant, let's leave it that way and not go from there. Mr. Walter. Mark.
Just from an economic development perspective of a very key property that is really conducive to small events and weddings and everything we're talking about. The present owner might be fine with 15 events, but that doesn't help. And I know Robert Powell has stated that a future owner could reapply for more events. But as Tom stated, if you want to put on this property that, double it to 30 events, it still makes it slightly more economically viable. 15 seems like a hobby, not a business. And I can't believe 15 would be enticing to sell the property to someone else who wants to continue this as a venue. So I would recommend you at least double it to 30, and that's still not that many. And that's my thoughts as the town administrator.
Thank you.
One of the things that could be done is that it be changed to something like up to 30 events, depending upon the location. Because this isn't for a particular property. This is for any property within the residential zone that's over 25 acres. And there may be some of those that 30 would not be appropriate, but a lesser number would. That's my
Okay,
2
so
cents.
we had the suggestion, and there's a potential for us to change after we close the public hearing. Let's leave on the table as part of the public hearing that we're going to have a discussion about what the maximum number of permitted events are, and it may potentially increase, potentially doubling or more than what is proposed by the applicant. I just want to get that on the public record during the public hearing, because if we expand what was proposed, I want to make sure we're legally compliant about what we can consider. Everyone follow my train of thought? You know, I don't know where we're going to go with this. I just
I
want
have,
to
I
do
have
it
a
correct.
question.
Fira, yes.
I have my question is if we change that number in the application and that has not been what has been advertised legally to cover us, kind of along those same lines as what you just said, Rick. You know, where does that leave us with the rest of, you know, the neighborhood or anybody else who might object to us changing and increasing that number?
I feel like we're well covered because it's come up during the public hearing. This is the public
Okay.
forum for people that want to weigh in on what our proposed regulation changes encompass. And that's why I want to get it on the record as something that was discussed during the public hearing. Then if we take action, if we went up to, you know, 300 events per year and it was never brought up during the public hearing, somebody might take exception with that. I don't know if they have a legal basis to do that, but certainly, you know, to expand by 20-fold what we had discussed in the public hearing, that's one thing. But if we've discussed possibly considering something at a larger number and the number was thrown out during the public hearing, I think that covers us. And I'm not an attorney, but it's a really good question, Vera, and I appreciate that you brought it up, especially during the public hearing.
Can somebody refresh my memory, maybe Paula, on how many permitted at Walt's Winery?
I can look in the zoning regulations. It's
Just
more
for
than,
comparison's sake.
I believe it's more than 15 because there's different things by different sizes.
And with that number, we also required a renewal of the application.
Correct, a renewal every 2 years. And we also require that, I'm almost there. We also require that the applicant notify the town, or that not the applicant, the winery, notify the town. I believe it's 30 days prior to an event, so that the town is well aware of the fact that an event is happening.
I'm just wondering if that should be something we should be considering here, seeing that it's in the RA zone. I mean, I know they're both large parcels, and I know it would be for a large parcel anywhere in town. But some food for thought when you're restricting one and not the other, and also having one required to up his permission every so many years and the other one not.
The special permit approval for the winery is, it's not an application, it's just the applicant requesting the permit to be extended, and it's just to ensure the compliance with the original conditions. And it's something that was put in place when the commission was drafting the regulations, just as a recourse to, if a particular winery is not adhering to the rules and the neighbors are complaining, then you have a recourse to just not renew the license. And it's also a way, if the winery wants to stay open, then they're have an added incentive to make sure that they're following the rules.
Yes, but do you see like
1 month in advance of an event, is when.
I would think we do understand that. So Vera, I'm sorry, go ahead.
But you see the similarity between the same type of usage between the two?
If you're asking me, I do see the similarity. But what I would say to that is, I think that the 30-day notice for an event is cumbersome. I don't think we ever should have put it on the farm winery application.
Right.
The potential renewal thing and to apply it to another property just because we have it, I think we need to correct it. That's probably should go on our list of things to address. Because we have we have a wonderful building department staff, but they are part-time, and getting action in a time frame that you need has to probably be challenging at times. But I'm not familiar with that, but knowing that maybe it's something that we don't need to have on the farm winery going forward. As far as the number of as far as renewing it every 2 years, I've always had a sense of anxiousness about somebody with a big capital investment potentially not being able to continue their business going forward based on zoning approval. And what I'm getting at is, I always look at an approval goes with the land without regard to the actual owner of that property. And I'd like to abandon that every 2-year review and renewal process. I think that would be something good going forward. I mean, what if you could put somebody out of business because you didn't renew the application for a less than reasonable reason after the fact? Have the regulations and have an enforcement process in place. But this renewing an application, I'd like to move away from that on all things going forward. I'd rather have, some sort of rules that we can discuss the enforceability separately, but I'm just trying to take shackles off of business in general. That's my attitude. I think you know that from the way we've discussed things in the past, but this is just one person's perspective. And I heard what you said, Vera. I'd be more inclined to not pursue those personally, and I'd love to hear what other people have to say about it.
Oh, I agree that I think that having a 2-year renewal and for 30 days is I don't think it's necessary, and I think it's burdensome. So I would agree that we should consider moving that at some time in the future.
Yeah, I
Rick,
think we're getting
I
away from the
absolutely-
actual application now. This discussion doesn't have anything to do with the application.
Sure.
Well, Rick, I'll just make a quick comment. I absolutely agree with you, and it's kind of like discouraging a future investment by a business by arbitrarily telling them that they have to have a maximum number of events per year.
I wasn't trying to get off topic. I was just trying to compare the actual number. And I think, it's maybe gotten off on the wrong tangent.
Okay, Rich had a comment. Could you?
No, I didn't care for it when we originally were getting that winery passed, but that's my position.
Okay.
I don't think we got off, Rick, I don't think we got off track at all. So, Bob, I really don't. I think that because they are somewhere in my head, I'm looking at 4.5 months. I think I might, just thoughts that are going through my head. I think maybe May 15th, not even want to do this, like May 15th to October 15th. I might change the hours, on Sunday, make it 11 to 7 instead of 11 to 11. And I think my biggest point is what Justin made too. I think that, if 5 years from now, these folks want to sell this place and they look at it and say 15 events for the year, I just think it just discourages any type of resale.
Well, that's not really a zoning issue.
No, but you're right, it's not. But again, it goes back to my thing of, the complaint that townspeople seem to have, or perception townspeople seem to have, is that we are not business friendly. And I think that fits right into that category.
But you have to remember, this isn't an RA zone, not a commercial zone.
I understand, but it's 25 acres too.
I think you also have to remember that this is the applicant putting the numbers before us. We're not putting the numbers before the applicant. This is an application from somebody. We judge it on their merits. Our job is not to increase the things that they want. They've asked for a certain number.
We can't modify
Why would we want to modify it? Why would we want to modify it?
for the reasons I've stated.
Yeah, but those are economic
I think-
reasons. We're not an economic development
Okay.
commission. We're a planning
Yeah,
and zoning
yeah.
commission
Should be
reviewing
open.
an application from an applicant.
Okay,
Okay,
I'm gonna ask,
It should be
to
left
be
open.
recognized before you talk. Rich has been trying to get in.
We're setting the groundwork for businesses like this and other locations around the town. So this is the foundation. So I think we do have a right to talk about what limitations we want in these areas as an overall for the next person that does it. So I agree with Tom, I agree with Justin, that provisions need to be made. I don't feel comfortable with anytime somebody wants to do something similar, they have to come and rewrite the regulations or ask for permission
Right.
anytime to do it.
Okay,
That's
I'm gonna
the
ask us
problem.
all on this, I'm gonna ask us all to keep all of the consideration in the context that we're not talking about a piece of land, we're talking about regulations for the town.
Exactly.
So
Yeah.
for whatever we're doing, this is a regulation change, not an application in any way whatsoever. So that's what's good for the town. The other thing is, in the case of a venue that would be doing this, the reason I think it's very limiting, and we want to consider economic factors, it may be a little outside of our normal range of purview, but I see event facilities like this, if they exist, being viable in the winter for indoor only events. And that goes way beyond 15, conferences.
right.
They have a very
Right.
treasured conference center that is vital and not high traffic, that somebody wants to rent for a corporate retreat or an indoor only venue in the winter. I think we have to look at how impactful our regulations are. And even though, Bob, I've changed from in favor of more at the beginning to limiting based on what you said. I'm back to thinking if we put in a little larger number, it's still a prudent number. And it's looking at the future of whatever in town, because the number could be too limiting on other properties. So Tom, let's talk about this after we close the public hearing. I just wanted to get on the table that we might consider a larger number while we were in the public hearing, more for legal protection. We can
And
go
Rick-
with it where we want to when we're not in a public hearing mode.
You know, folks, we are called not just zoning, we are called planning and zoning, and this to me is a planning issue.
Thank you.
Exactly.
Any reason why we should keep the public hearing open from anybody? Because if not, I'd like to close the public hearing. We do have some notes that we made. Very likely, we're not going to take action on it this evening unless somebody feels a compelling reason to push it forward this evening after we close a public hearing, if we close a public hearing. Again, when we have a regulation change like this, I'd much rather see a cleanly edited version and that we vote on it exactly how it's going to be implemented. Just is way more simple than a motion made with exceptions to the current verbiage. So with that said, I'll make a motion that we close this public hearing.
Second.
Any discussion on that? All those in favor of closing it? That would look unanimous to me. Vera, close the public hearing?
Aye, yes,
Aye.
yes.
Tom?
Aye.
Okay. Public hearing is closed. I want to thank you, Mr. Glut. It's a very well thought out application. So we're going to go into our non-public hearing mode as soon as I open up my paperwork here. Please bear with me while I bring up the agenda. Okay. Next up is unfinished business, item 6.2. It's the application of Valley Street Investments LLC for zoning regulation amendment to section 9 definition, section 21.2.3.16, and section 52.7.5 to allow an event wedding venue in the residential agricultural district. What's your pleasure as a commission? You think we could potentially get to a vote tonight? I think the only open issue that we have We brought up some very specific items. I made scratch notes here and tell me if I've forgotten anything. One had to do with referencing a licensed traffic engineer acceptable to the town planner. Defining low level is not at all audible off-site. The sign change I didn't have a problem with. Inserting the word shall somewhere. Do you,
Yeah.
I think Greg pointed out something where it was missing in the verbiage.
Yes,
And,
I caught that. I have, while you were working on this as a commission, I was drafting a motion. So I do have that, but again, it's your preference as to whether or not you want to
Okay.
wait or not.
Let me ask a general question of the commission. Is this something most of you are inclined to approve? That's not a vote. That's just trying to get an idea of where we're going, whether we want to move this forward or not. Because if I had 80% of you not inclined to approve it, then we'll vote. We'll come to a vote and move on from this. I'd like you to each speak about your perspective on it because I want to hear from everybody that has something to say about it. Mr. Walter?
I would just caution of using words like not at all audible. From a law enforcement perspective, if two neighbors are battling, I mean, you can hear their fight in their house. You can hear weed whackers, lawnmowers, but not at all audible could be hard to enforce if police were brought into an issue.
Okay. So we would need something that works. So Paula, can you weigh in on this? Any thoughts? We can't have Mr. Glad weigh in because the public hearing is now
It's closed.
closed.
I phrased it and not audible beyond the property boundary. Which when there's two property owners disagreeing on something, there isn't a language that takes that out of a possibility.
So that wouldn't cause a legal,
Not audible beyond the property boundary. No.
so not, I won't use not at all. I would not use that
Right.
definition, but not audible. And
I would
okay,
agree. That'd be better.
okay, that makes sense. Thank you, Mark. I appreciate your comments. With the addition of that, I've flip-flopped from one position back to a compelling argument made by Larry and Bob to back to having a perspective that I think a slightly expanded number than the very limiting. I think 15 is very limiting. And I look at what makes a good regulation for the whole town, not for this applicant. And I think increasing the number to a larger number would be advisable. The minor changes, any changes to the event hours, I think the way it's presented as modified this evening and with the minor changes to licensed traffic engineer, inserting the word shall in the correct place, not audible, with regard to the off the site and have I missed anything?
The only hours I kind of object to is the 11 o'clock on Sunday night. I think that should be, I don't know, 9 o'clock on Sunday night.
Okay. How about if we put change the regulation to reflect that 9 p.m. time frame on a Sunday evening for now? That work for everybody? Paula, I've got a question about what you feel about.
Did you get an answer to that? I don't know if there was any, I'm not to interrupt back. Was there an answer on that?
No, nobody voiced disapproval.
Okay.
I'm gonna take that as we're gonna go that way, and please weigh in. I don't want to make decisions. I want what goes on here to be all of your perspective. So is there a general desire to vote on this evening with those modifications? You want to discuss the number of events? I would like to see a little larger number. It just doesn't seem like a realistic number for other people. Let's take this out of the hands of what the applicant may want to do with their property. I just want to see a larger number of potential events. And I'd love to see multiple event facilities like this in town where there's the ability to host inside events in the winter. I think that's nothing but a positive for the town and for use of some properties.
Do we have to determine a number tonight on a number of events?
Well, if we're going to
tonight?
vote on the final regulation, and I don't know that we want to, maybe we want to banter this around into our next meeting. There's no rush to vote this evening. I would say the latest we want to do this would be by our next meeting. Mr. Walter?
I would just wonder if the time, the maximum time an event has to end by could be determined by each property. Let's say you have 100 acres and no
No,
one
we
can
can't
hear
do
you.
that because this is a townwide regulation. It's a townwide regulation, not property specific.
So what I think Mark is proposing is that we change the verbiage to say not to exceed, but maybe modified at the option of the commission during the application process. So I think what he's suggesting is give us the power to say, okay, this is the maximum amount allowed, but in this case, this property is not appropriate for those number of hours. Is that
correct?
Yeah, I think that's a very advisable thing. Rich?
Doesn't that lead you into almost spot approvals and down that slippery alley, spot zoning?
It does give discretion to the commission, but that's kind of why we have the commission instead of a set of rules that if you comply, you don't have to do an application. That's the purpose of an application review, is to apply that as it applies to that particular piece of land if we were to have this regulation in place.
Okay.
Commission is allowed under the special permit regulations, which this falls under, when an application were to come forward to make conditions, and the conditions could be, event hours are limited to, they start at 1 PM and end at midnight for whatever reason. But I mean, it's something that the commission would be able to do because it is a special permit.
The proposed hours, if we simply added the verbiage up to,
Yep.
would I think encompass what was suggested here, and I think it's a great suggestion.
You might want to adjust it on Thursday night also because people go to work the next day.
Good point. Very good point. I
Yep.
think
Yep.
changing it to say up to, so that each special permit that we review, we have the discretion to reduce the number of hours from these requested hours based on the site itself. And that's what our responsibility is.
I think it needs work.
Paula?
I would
suggest-
say, I'm sorry, go ahead.
I'd suggest that I'm not just directed to you, Paul, I'd suggest to the commission, we've give Paul a specific direction to work with the applicant and make the changes as we've discussed tonight. Let's come to a perspective on whether we want certain changes. I think the up to on the hours, is anyone in disagreement of using that terminology?
No, it's fine.
Makes
That's great.
sense? Yep.
That's great
Okay.
terminology, Rick. Maybe you should use that for the number as well, number of events.
And limit the number to a lower number based on the site, so that let's go with a larger number, but you have the option to only allow a limited number. That's perfect. That's excellent. That allays a lot of concerns that I had about going to a larger number. But the number I would throw out there is 30 at this point as a new regulation, and use the term up to 30. And then we have the option, and if it's an event that's in an area that we have concerns about, or the nature of the topography is such that we want to limit, perfect. Thank you, Bob.
You could also write into the thing that at the discretion of the commission. Up to 30 events at the discretion of the commission.
Yeah, very good.
Perfect. So Paul, you're taking notes on this?
I am.
Okay.
Rick, I still have a problem with 30. I mean, if you start talking 12 months a year, you're talking 2.5 events a month. I don't know. I think it's too limiting.
Okay.
We don't
Let's
have any limitations on the number at the winery, do we?
Yes, you do.
Yes, we do.
Yes.
What's the number?
I
Did you
closed
miss
that-
the last 45 minutes?
No,
Come on.
never mind. I mean, I just think, I don't know.
I don't think we should have those limits at the winery, but that's another,
Yeah,
another
and I don't think
point
they should be
altogether.
limited here either.
Yeah, if you think the number should be larger, let's discuss that in more detail when we have the final version of the regulation with everything. That would be the only thing that we would probably potentially change. But the suggestion of up to, Justin, you were going to say something?
Yeah, I'm afraid I'm gonna get pilloried for asking this question, but I'm gonna ask it anyway. So there's several levels of protection here. We're talking about sound, we're talking about size, obviously with acreage. What is the harm in just taking out the maximum number of events and leaving that up to, because if you have 100 events a year, but you're within the decibel levels and you're within the restrictions that are set forth, or nobody would ever know that you're having an event there. Like, well, why would we even consider making those restrictions in the first place?
I think it has to do with changing the character of a neighborhood due to unrelenting traffic.
The key to this thing is that it's in a residential area.
Yeah, I understand.
It's not in a commercial zone. It's not in an industrial zone. It's in a residential area. And you're putting a commercial venture into a residential area and the effect that it has on the people that live in that neighborhood.
On a very
Rich?
small road.
Hold on one second. Rich was up next.
All right, why don't you just limit it to the number of events per week? So if they want to spread them out through the year, if they want to condense them within a small time frame, that would leave a lot of flexibility without a super lot of events. But it would let you operate year round. Just come up with a magic number, 2 events a week maximum. In a residential area, if it's in a commercial or industrial area, it's a whole different ballgame.
That's an interesting thought. Any thoughts? I'm sorry, Alex, you were going to say something, but let's talk about what Rich has said.
I disagree with Bob that, but the road is really a question, and this property, maybe others in the future, how big the road is. But Rick's
I understand.
point of limiting it to how many a week makes a lot of sense to me.
I'm sorry, I'm having a hard time hearing you, Alex.
I said Rick's idea of limiting events, certain number of events per week makes a lot of sense. It solves a lot of issues.
Okay.
We could make a matrix, and we could put on there a whole different schedule as far as matrix of, if you have 5 acres or more, you're allowed so many people. If 7 acres or more, you're allowed so many people. 20 acres or more, you're allowed so many other people. Like we did with the lake zone for square footage.
Oh boy, that
You know,
I'm not in favor of that.
No. Yeah, remember the matrix for height? How long that
Yeah.
So Rick, that kind of, so that exemplifies my main concern. Like if I'm going to bring this into all together for me, you can't have a number on the number of events, because it could actually be argued that if someone were to push this at 15 events, that it works for this applicant, it's actually discouraging someone in the future. Plus, unless you actually were to do a business study, a business case, and take all of the averages of what the revenues needed, the gross profit, the number of events, what the overhead is, like from a business perspective, to come up with a number, that's the only logical way you could do that, and that's too burdensome.
That's
to
not
me, you
within
would
the
want to make
realm-
it more open-ended.
I understand.
And that's not a zoning issue.
Yeah, hold on one second. Vera.
And exactly.
Okay,
Exactly.
Justin, just a minute. You're going into areas that are not zoning issues. They're not really planning issues. I'm just saying, a gut reaction is 15 was a limiting number that was too low. To try and establish what a reasonable number is based on absolute economic analysis, that's just so far outside the realm of what our purview is and our charge is as a commission. We're talking about land use and impact on neighbors, not economic analysis. When something's presented to us that just doesn't seem to make sense in whatever way it doesn't make sense, let's keep the discussion more simple than that. What's a reasonable number? Either do we want to go in the direction of events per week or events per year? The applicant proposed events per year. That's what was on the table. This could take on a life of its own. I'm just suggesting expanding it somewhat. I don't agree with Tom that going way past the number 30 for right now is advisable. Somebody else has something and they need it more than 30. And using the term up to that Bob suggested, I think is an ideal way to let us at least get started down this path. I don't want to bite off more and analyze what ifs that never may come to consideration. So that's
and-
my personal view.
No, and I 110% agree with you. That was actually my point. I mean, in the absence of getting into that level of minutia, which we never should do, I think we just need to be a little bit more open to the number of events. That's all. So
I would be at this point in favor of establishing the number at 30 and use the term up to. We're on the record of saying we're open to more, but right now capping it at 30 for the time being, I think that's a number I could live with without digging deep into this issue. Rich?
I don't mind the number 30. What I mind is 30 events. If you combine it, if you put it into a nutshell from July to September, that's, you know, every other day do an event in a residential area. And that to me would make things way more uncomfortable for neighbors there versus, you know, pretty much limited to a couple events a week, maximum 3, whatever the commission wanted to, let you spread it out and have the events you need to succeed and create your income flows or whatever you want to do. Though we're not going down that avenue, but from a business perspective, it lets you be more versatile through the year, holding different events. Not everybody gets married in the summer. Some people get married in the fall. There's different events, different times of the year, and there's busier times in the wintertime. You may be
So what are
doing
you
more stuff.
proposing?
I'm thinking somewhere no more than 2 or 3 events in a week, any 7-day period, and leaving it at that. And that way there.
How about 30 events per year, not to exceed 3 events per week?
Whatever, that's up to the commission. I think you need to be able to spread it out versatility. So that would be up to the commission. You want to pick a number like that?
Any
In a
thoughts on
resident,
that? I hear what Rich is saying, and I respect his thought process. We don't want too intensive a use in a residential neighborhood. We don't want to see something 7 days in a row. You know, if there's a festival that's mostly indoors but has traffic 7 days a week for 2 weeks in a row, and that's
The application is only 4 days, Rick.
I'm
Yeah.
sorry.
The application only shows 4 days operation.
I apologize. I
per week,
forgot that.
per week.
but someone might say they're going to run a whole bunch of seminars or weddings or whatever back to back. So they're going to do 4 this week, 4 next week, 4 the week after that. So if you limit the number per week, you don't have them bunching it all up in a shorter period
Okay.
of time.
Let's put this out. I'm going to move this along because it's getting way long in the
Just
tooth.
want to say one more thing here, and that is,
Yeah.
I'm going back to Bob, and this is what is planning and zoning. It's not our job to be second guessing the economics or what it is that the applicant is trying to do. Our job is to encourage business, but also to protect the the neighborhoods and whatnot. This is in a residential zone. So I would say, hey, if the applicant says 15, go with 15. And if they find this works out well and they'd like to expand it, and if we find that there are no complaints or adverse effects, then they're free to come back and we're free to increase this at any time. But to me, I think we're getting off trying to micromanage somebody else's business. And that's not our job as planning and zoning.
This is not, no.
Okay, everyone's expressed their views on this. I'm going to take it that we're not going to vote on this evening. I want to make a suggestion. Paula, can you draft all the changes we put in?
I will.
Leave the applicant's original, leave the applicant's original 15 number as proposed in the draft. And let's talk about the number of events and possibly a different number if we want to at the next meeting after we've as long as all the other things are well defined. So we're licensed traffic engineer.
Not audible beyond the property boundary.
Sound not audible off site. Let's see, the traffic engineer acceptable to the town planner. Insert the word shall.
Yep.
Let's leave the number at 15 for the sake of moving the document forward for the time being. And let's go to 2 weeks, our next regularly scheduled meeting, and let's have a conversation and limit it to the number and think about it. I would be in favor of more because I think as a town allowing more events, because I don't see these as big sprawling outside events. I see I see a conference center business with great potential. There's probably a lot of structures in town that would support it. I'm personally in favor of, I know where I think we all know where each of us stand on limiting the number. To get into a number per week is just it's cumbersome to set up a way to come up with a right control there, but that's my personal view. I don't want to sound like I'm speaking for the commission. I hear what Bob and Larry said. It's not up to us to expand what was proposed. I don't have the same view, but I respect what they say. Just is how we treat each other here. If we can differ on it, I would personally like to see more. I want anyone else to weigh in, but let's leave the number at 15 for our next meeting, and let's focus on that one issue if we can and not get off track and discuss the number and go forward. But I'd like to see this move forward, and I think we're, as a group, likely to approve it with the minor changes as approved. The only thing we don't probably agree on right now is the maximum number of events. Worst case, we approve it as proposed, and the next applicant that wants more events has to propose something. But I do want to put the word up to on the description of the number of events, because I want to have control over that through the special permit process. And that's why I'm comfortable going to 30, because it would say up to. If we have a site that doesn't feel conducive for that intensive a use, great. Tom, I don't think you're going to get us past 30 on this one.
No, that's right. Well, I just want to add one thing. I went to a presentation last Friday at a building in back of Tim Ackert, a nasty word, Tim Ackert's building in Coventry. It was one of the old mills. And
Yep.
there were 10 people, and then 2 people did the presentation. We were there from 9 to 12, and they brought in lunch. I could see this place doing something like that. So you're 4 hours on a Friday, 9 to, we did it 9 to 12, and served, they brought in catered lunch. There are probably 10 cars.
They don't see that at this point, but
But somebody might.
Okay, so they might, but no one has. Let's try and move this forward by compromising.
Okay.
Let's
I just
not go
wanted,
way past the number,
Let's
please.
stay on topic.
One of the phrases that I believe Rick had mentioned, that there's we include the phraseology at the discretion of the commission, which falls under the special permit approval anyway. So even if a particular location, maybe a particular location, Sundays aren't great. So the commission could then say on this
Yeah,
particular
that's
location.
not what we were talking about right
No,
now.
I
Paul.
realize
We're
that,
just
but-
talking about the
okay.
number of events, and I don't want to really
Okay.
continue the discussion much tonight. I'm trying to move on to the
All
next.
right, I'm
topic.
sorry, I apologize. I'm
Yeah,
just.
this gotten way past where I want it for this evening. We certainly need to discuss it more, and we talked about it enough tonight. I hope you don't mind me pushing it this way. Let's just move our meeting forward. Okay?
Amen.
So,
Amen. Let's go.
okay. So next up, so we're going to continue this discussion to our next meeting. I really would like to see us take action at the next meeting.
You're
But
continuing
Paul,
the
if you
public
could
hearing?
draft the regulation, modify
Right,
what
close the
was
public hearing, okay.
proposed to reflect what our discussion was tonight, and I'll make sure at the earliest time, take a look at it, make sure it encompasses what we want. Let's, for the sake of discussion, even though I'm in favor of 30, let's leave it at 15, and that's probably the one item we'll discuss at that next meeting. Okay? Rich?
I have to step away, so if you want to have Justin or whoever's available sit in for me. I have to take care of some stuff.
Okay,
I have to leave the meeting.
okay. Good night, Rich.
All right, thank you.
So, Rich, you're seated from this point forward, if that's legal.
It's perfectly legal.
Okay? Thank you.
Have a good night, everybody.
Hey, Rich.
Next up is item 7, and that's the only other thing we're going to discuss tonight. We're going to take and defer on everything else on our agenda after this to our next meeting. So let's talk about interpretation of zoning regulations for solar, as it was brought up by Mr. Tabor at our last meeting. Thank you for your, I hate calling you Mr.
Can you hear me okay?
I can hear you just
Perfect.
fine. Thank
Yes.
you. Thank you for being
Okay.
here.
Walt Tabor, 544 Route 87, Columbia. And this is an interpretation of the regulations, but it is the app where the discussion is somewhat specific to 468 Route 87, which is also a property that we own. Rick, do you want me to kind of recap what I brought up as a point of question last time?
If you could just phrase this, so the question, I just want to phrase to the commission, the question Walt is having is if he wanted to put a solar farm of X size on that property, regardless of the intent of the regulation, is the exact verbiage allowing him to pursue this. And if not, he wants to gain a perspective, because it's the town planner and the town zoning agent's perspective that what he wants to do is not allowed. And he did write us a letter dated July 26. He did write us a letter, and we'll go back through the letter. But if you could recap this, and if I've said anything inaccurate, please help.
I just wanted to add that the town attorney agrees with the town planner and the CEO. And it's,
Okay.
it's because of the specific language, which is an easy thing to modify.
We'll get to that, Paul. And I'd love to see all documentation of the question that was asked of the attorney and the exact context that he answered that question. And I'd like to know what question was asked and what his answer was. So if
That was
we're
all
gonna
sent out
take
in
that
the packet. You have all that information was sent out in the packet.
Okay, do we,
So let me repoint the question, and because I'm not sure that the question that I asked was posed to the town attorney. And this is directed to the commission, not to the town attorney. Can you hear me okay?
yes, I
Yeah.
can, listen.
Yeah, you're okay.
The point being that the regulation, and I understand the regulation that was written with the intention of being support for single family dwelling on a single family lot in the residential agricultural zone. What's happened is the regulation that was written is non-specific. And I'm not criticizing it, I'm just saying that it is non-specific. And if you take it for its specific verbiage, it does not define what accessory means. We have to defer back to the definition of accessory. It doesn't define the size of the solar system with regard to how big it needs to be an accessory. So it's become so non-specific that when you pose the question, I have a 56 acre parcel and I want to put a 10 acre solar field on it as an accessory use, meaning that it is subordinate to a winery that's already on the property. Does it fall within the guidelines of what was written in the regulation? Because the question then becomes, if it doesn't, do we need to rewrite the regulation? But if it does support it, or if it does, based on the verbiage, allow it, and the commission opts not to rewrite the regulation for the purpose of a solar field that size, that would determine whether or not the shoe fits in this case. Is that clear? I want you to understand, I'm not trying to manipulate the regulation. What we're faced with is we have a regulation that by its verbiage doesn't specify how big or how small a solar field is. It also doesn't define whether or not it's connected to the dwelling. Those are interpretations that are being made by Connie and Paula. And by that interpretation, they are prohibiting this solar field. Now, somebody asked at the last time we brought this up, which is 2 weeks ago, Alex, I believe it was, what does a 1 meg field look like? And I guess I went back to the solar company and I asked them for specific, and his point was, well, there's no way to define that. It's just like there's no way to define what 100 kilowatt system is, because it depends on how far apart the units are spread. But he said for a general term or for general definition, you should consider a field of 1 meg to be approximately 10 acres. Now, if the field is spread out more, it could be 20. But if the field is condensed more, it could be 5. But he said to use a 10 acres as the size. Now, so we're talking about a 10 acre field on a 58 acre parcel, subordinate to the primary use. Does the regulation fit that?
Okay. Does everybody understand the question that's before us?
Yeah.
Sounds almost like it's a legal question. I don't think there's any, I don't think there's any question that would be in favor of doing this. It's just a matter of whether our existing written regulation allows it or not. So what's the, has our lawyer taken a look at this? What kind of guidance are we
have
getting?
communication that's gone from Mark, started with Mark Walter, and this it's on page 12 of the packet, 11 and 12. There's a bunch of communication.
See, I'm of the opinion that if someone moves into town and they buy a parcel and they become a new resident in town, and they buy it based on what the verbiage of a regulation is and what they're allowed to do with that parcel, that the verbiage should be correct. So the question is the verbiage that's there correct or isn't it? Because if it isn't, does that suggest that it should be rewritten, or is it correct and that it actually allows it? Because
Let me.
I don't
let
know,
me,
I don't know who would read it and say that it was defined. Nowhere does it say that it is connected to the dwelling. Nowhere in there does it say how big the field will be. So you'd have to ask yourself, would a 1 meg system in that situation be any greater a challenge on a 50-acre parcel than a 100 kilowatt system would be on a 1 acre parcel? And on a 1 acre parcel, there is no public hearing. It doesn't matter who you put, where you put it, as long as you meet the setbacks, and your neighbors have nothing to say about it.
So I think
So
the question.
again, I refer to the actual
Excuse me.
language of
Yeah,
regulation.
hold on. What? Could you give me a second? I think the question that is being posed to us, because I want to streamline this. Somebody's ringing. I think the question that's being posed to us is, do our regulations specifically prohibit this? Not did they intend to, but do they? And what is it in Rich Roberts' response here is stating that this is not encompassed by the regulation as it's written. And it's so it is a solar farm that's 1 meg. Can we consider that an accessory to a winery operation that is run on a parcel? In this particular case, could be a different operation on a different field elsewhere. And I think looking at the question in that narrow context is probably the most effective way to evaluate it. You can look at what the regulation intended, but what does the regulation say? And there's no question that we're the ones that interpret the regulations. Now, the zoning code enforcement officer has the power to give a perspective to an applicant coming in. And we don't have the power to overturn that, but we can give a lot of guidance to the zoning code enforcement officer. And if the zoning code enforcement officer comes up with a perspective on an application, there's always the ability to appeal that to the zoning board of appeals. But I think having clear understanding about the commission's perspective on a regulation when it is somewhat nebulous, I think is one of our vital roles here. And I would want the commission to weigh in. So if our and from our attorney's perspective, Paula, was it Rich Roberts' perspective? How is it that he feels that there's no way that this is an accessory use?
Based on our definition of accessory, which says that the accessory is defined as that it's subordinate to the primary and customarily incidental to the principal use.
So it's
So
a
like a house, it's
subjective
a garage.
criteria.
Yeah.
So he gave us a subjective perspective on a subjective criteria.
Yes, he felt that a solar farm was not customarily incidental on a residential or a winery property.
So I think that we can form our own perspective on that, because I think that what we think is more important than what he thinks on this. And I respect Rich a lot, but clearly the perspective of the commission is the most prominent factor here. So let's go around the commission if you feel like you have enough information on this. Is this something that you think the zoning enforcement agent should look at as this is permissible in the context of it being a 1 meg field? And this is not a specific application before us, because it's not an application, it's an interpretation of how a regulation should be applied.
Rick, can I ask that either you or Paula read the actual definition of an accessory? And the reason that I ask that is because it's brief, number one, but it also states public utility.
I'd be happy to. It says a use, building, structure, retaining wall, public utility equipment, fence or outdoor storage container that is subordinate and customarily incidental to the principal use, building or structure on a lot.
So public utility structures included in it.
Is that, yes, is that customary, subordinate and customarily incidental to a winery?
Well, you'd have to say then, Paula, that if it's in a residential neighborhood and somebody's doing it to support their home, that too would be subordinate to.
If it's a
Would be
solar
accessory
panel that
to-
is feeding the electricity to that house, and then the overage goes into the grid, yes, that would be, we.
I
that's what
appreciate
all
you
of us-
reading
It's
the,
solar is becoming customary use.
hold on a second. I just want to frame this. Paula, I appreciate your comments, but I'd really like to get a perspective from the commission on
Yes,
this.
I just muted myself, so.
Okay.
Can I make
any
a
thoughts?
comment?
Please.
The electricity, the solar works by supplying, in my case, I think most homes who have solar panels, electricity is not supplied to the house. It's supplied to the grid. You get credit on the grid for what you use. In my case, I have 0 electric bills. So there are times when I build up a surplus that I'm not sure I'm going to use. So
Somebody's
I'm
contributing background noise here.
Not me.
I would really appreciate whoever is contributing background. Thank you.
So I don't think Walt's 10-acre field, if it's supplying power to the grid, is no different than a house. The question would be, how much more power does that make it a commercial operation? But the
Good point.
technical supply is the same.
Mr. Walter,
From the state's view, and we actually joined a lawsuit years ago over this and pulled out of the lawsuit because the state was not going to differentiate between commercial, residential, or anything. They were stating that solar is non-taxable, period. As a property tax, whether it's residential or commercial. So that's why when this was a 3 meg operation and handled by the siting council, we did a purchase and sale agreement or a contract with this solar operation that they would voluntarily give income back to the town in spite of the fact that the state did not require it. So that was how we were going to combat the state's non-taxable aspect of solar. So the town is comfortable with this field supporting the winery, whether directly or indirectly. As to whether we get hung up in the definition, which is where the town attorney was brought in as ancillary to the winery, I think that's splitting hairs because solar is a credit. It's never directly firing up your house or your business. It's a credit to the grid that you benefit from. And in my perspective, and doing this in multiple towns, a solar field is a better use of a farm field that can be reclaimed in 20 years as opposed to a residential neighborhood that is there permanently. So that's just my opinion as your town administrator.
thank you.
Hey, Rick, Tom here. I guess my interpretation of not only Rich Roberts, but I think for this, parcel and for other parcels in town, I think it might be cleaner if we just did a new regulation that allowed this type of thing. Because I think when you get involved with defining if it's accessory or subordinate, to me, it's gray. It's a gray area. Because it's not going to the house or whatever, or not attached to the house or, in the yard or something else. This is, to me, more of a commercial enterprise. That's my feeling. I'm done.
Okay. Bob, I saw you nodding. Your
Yeah,
thoughts?
I think the town attorney also suggested that, didn't he, Tom?
Yes, I'm reading, I've got it right in front of me, Bob.
Yeah. So, I would err towards the town attorney. He's in the business of interpreting this stuff. We aren't necessarily. And he has come up with a pretty simple suggestion, I think, that would allow for this. It's
Yeah,
just a
he's saying
question-
if it isn't permitted, it's prohibited.
Right, but he also put together something that says either primary or secondary, I believe, right?
Right, yes.
So that
Yeah, a little
in
confusing.
effect would, I think, solve the problem.
Right.
Larry. I want to
Yeah, I
hear
think
from
if it's-
everybody.
I think we're all in favor of this, so I think that the clean thing to do is just to amend or rewrite the regulation to make it all clean and legal, and we don't have to worry about any kind of a legal problem laid, downstream.
Okay.
Rather than trying to argue whether accessory and all the rest of this sort of thing.
Yeah, just do a new regulation.
The verbiage we have now wasn't intended to cover what we have here now. So I think we should just change the wording to include what we're trying to do right, what the town and Walt are trying to do right now. So it seems like that's
Okay.
the cleanest answer.
Vera, what are your thoughts? Justin, any thoughts?
I mean, it seems to me that the function of it is the same, regardless of whether it's a smaller system for residential or larger in this case. But I hate to add more verbiage and regulation, but if that clarifies it, then I'm not opposed to that.
Okay, Alex?
I think we should rewrite the regulation.
Okay. Vera, are you still there?
Vera's
Okay.
muted, if she could unmute.
Notwithstanding that I have a friendship with Walt, I thought we could hopefully stretch the regulation because inevitably it's going to probably happen. But if you think that the most clean way is to approach it with a regulation revision, and that's going to be a much simpler thing than having them go through the siting council. The thing is, if this goes through the siting council, we have almost nothing to say about it. Nothing. And okay, Paula?
Yes, Rick?
If we decided to make a minor regulation change that would permit this, what's the most timely time frame that we could likely do that?
It would take about 30 days. You could do it.
Okay.
One
Everybody-
question, I mean, this would be for is section D under there. I'm the one that wrote these, and it's my mistake because when I wrote this, section D was for solar farms, and it never occurred to me that a solar farm would be on a piece of property that had another use.
Right.
It
Well,
never occurred to me. But this, one of the things that the commission has always been concerned about is the abutting properties. The regulation, so when this was adopted, the regulation said that the solar farms would be by special permit. So the commission could make sure that the backyards of houses that looked into something wasn't overlooking a solar farm, a solar array. Would you still want, if we're going to be revising it, would you still want this to be by special permit?
Can I kick in here for one quick second?
Sure.
On that same subject, that same matter, and that is that currently the regulations allow on a 1 acre lot, actually half acre lot. There's, again, no lot size is determined here. a single family dwelling can put a solar field in on their property the way they want it, how they want it, and their neighbor has nothing to say about it. You realize that? I mean, that's what the regulation says today. We talk about this, and we talk about a 10-acre field on a 58-acre parcel. The neighbors have to weigh in on it. Is there a difference?
Yeah.
Yeah, there is.
Does
Yeah,
the town?
there is. Yeah, I
Okay.
think there is.
And why does that, Tom?
Well, I think because you've got 10 acres of solar panels as opposed to somebody being on their roof. I
Or in
guess,
their backyard, or in their backyard on a
yeah,
pond.
but it's affiliated or associated with a house or a dwelling as opposed to a business. I just think it's going to be neater and cleaner, not just for your situation, Walt, but down the line for any other parcel.
What we're
Yeah.
faced with, and I guess that's why I'm sitting here, is that.
I understand.
This is a case that's before us right now because someone has invested a lot of time in making this happen, assuming that the regulations, based on what they say now, that the regulations pertain to what they're doing. And we're finding out that they're not. But if, Paula says this could be turned around in 30 days, I'm all over it.
Yeah, Paula,
Yes.
I think what we'd like to do is, and well, I think this is going in the direction of a special permit approval, because it's gonna go on in a residential zone, potentially, but that's where the land is. And it's going to be something nobody wants to look at, to be blunt.
Kind of like a wedding venue.
Yeah, actually. Yeah,
Exactly.
nobody wants to be within 100 feet of what's going on, and nobody wants to have the solar panels reflecting off of a hill into their house. And so in terms of scale, it is bigger than what we thought of as a residential solar array that was on a typical house. On a 1 acre lot, it could be a 15 kilowatt array, but we're talking something that's not much bigger than the size of a house, not measured in acres.
I got
And
you.
I think that the cleanest way to get this done is to do a regulation change. Paula, can we still do all the advertising online and we don't have to do the
No, we
newspaper?
have to submit it. It has to be in the paper now. I lost the name of the company, the United States Solar Corporation. He had offered, the beginning of July, he had offered to submit a zone change text amendment. So I don't know if we should take him up on that and have the fees go to him, or if you want us to.
Well, if we can get him to
the-
pay for it, that would be better than the town, but I don't want to slow it down.
Yeah,
Whatever we have, I want the verbiage of the proposed regulation change for our next meeting, so we can decide how we're gonna go forward with this.
Do you want me to go ahead? What will expedite it is if I can predetermine when the special meeting, the public hearing date would be. That will make it faster than waiting 2 weeks for you to say, yes, the language is good, and then set a public hearing. Then we're talking 6 weeks and not 4 weeks.
Don't we already have the language as proposed by the town attorney?
Yes,
It's 1, 2, 3, 4, 5 words to be added.
it's correct.
Okay, so set the public
I'll
hearing
s-
date at the earliest possible date.
Okay, I will do that.
And if he doesn't want to pay, then we will.
Okay, will do.
Is everyone good with that? I don't mean to speak for the commission. That's really a commission decision. Are we all good?
Yep.
Okay,
Thank you, folks.
okay.
Thanks, Walt.
Thanks, Walt.
Appreciate your help.
I know the town is, as an entity, through our town administrator, would like to see this done. The applicant would. I think we're supportive of it. I think we just need to do it in a way that's really clean. And so,
I agree.
I agree.
okay,
Okay. Thank you very much.
thanks.
Night all.
Thanks, Walt.
Have a good night.
Okay,
Thank you,
the
Walter.
rest of our agenda, I'm going to suggest that I'm going to make a motion
Can we
to,
do
anything pressing,
can I
Paula?
ask a favor?
Sure.
That you guys read the section that I did a 2-page, part of the last 2 pages that's on the legislative actions and the zoning regulation. We're gonna need to make changes to our zoning regulations.
I don't know that we will make.
I'm not
changes, but-
asking to discuss it tonight, but just
No,
read.
no, I'm not,
please.
we're not going to discuss it, but what is it you'd like us to do with regard to those things?
Just to become aware of the changes that we're facing and the deadlines.
We did discuss those at the last meeting, what they were. So,
I detailed them a little bit better. I think it's the last 2 pages. I'll send them out as something just for, with just those, just for you guys to think about.
and one
Yeah,
other
it's
thing,
in the package you sent out, right?
Yes, correct. I just
Yeah,
don't want us to all of a sudden say, oh, and
yeah,
tomorrow
it's the
everything
last
changes.
couple pages.
Yeah,
Yep,
Yep,
7/26/21.
yep.
got it.
Okay,
I
and
promise to not test you next meeting, but I'd appreciate it if you'd read it.
also, one thing briefly that we talked about was maybe holding these affordable housing seminars regionally. If we haven't done anything on that, if we could come up.
Oh, you
I'll
mean
talk to the affluent-
the training sessions?
the
Yeah,
training sessions.
yeah.
Okay,
We've
let's try
got
and,
some time to think about that one. That one's not until next summer,
okay,
so.
I'm gonna make a motion, we adjourn.
Second,
I'll
Excuse me.
second that.
Did
All
you
those
have an
in
audience
favor?
of citizens at the end of your meeting?
We
Or am I
decided
wrong?
to adjourn. I'm sorry. Do we want to not adjourn now and go back into audience of citizens?
sure.
It's on your agenda.
I'll withdraw my motion. Yes,
Thank
Ms.
you.
Kabala?
I do not have anything to say. on the agenda. So, thank you.
So there was no reason to
Close it.
withdraw the motion to adjourn. I make a motion to adjourn.
Second.
Okay, all those in favor?
Aye.
Aye.
That's unanimous. Thank you. Good night, everyone.
See you
Good night,
in 2
guys.
weeks.